Hey guys, welcome to this episode of Street Cop Podcast. I am Dennis Benigno. I'm your host. I'm the founder and CEO of Street Cop Training. I'm here with Zach Miller, who is one of our instructors, and I would even argue maybe the lead instructor for constitutional policing, a case law expert, a guy who spends his life doing the best he can, chopping through case law, making it digestible for us to understand. And he's a real blessing for us to have him with us on our team and to a bright, great future together. But without further ado, hey, Zach, it's been 3 weeks. Where the fuck you been?
It's been a while. Hey, I need to take some time off. Went on a little vacation. So good to be back, though.
I get it. Go anywhere interesting?
I went to the Outer Banks.
Oh, okay. So no place interesting. Yeah, cool.
Interesting
Gotcha.
Yeah, so.
You like looking at the crabs at 6 o'clock in the morning?
I don't get up that early. Not on vacation.
Oh. No, huh?
No.
Hungover a little bit?
Just chilling and relaxing. That's it.
I got it. Fair enough. All right. So today, what are our topics we're going to talk about? Where do you want to start? I know you'd mentioned Miranda to me prior to this. Would you go with Miranda to start?
Probably Miranda, but I did right before we came on. I got an interesting message about the recent Second Amendment case that came out of the Fourth Circuit. I just wanted to touch on it real quick because one, it's an interesting case, and two, it gives an opportunity to talk a little bit about how the court system works. Because the question that I got really dealt with, well, what's the next step? So there was a Fourth Circuit case, Court of Appeals case that came out the other day called Hirschfield versus the ATF, and it's a Second Amendment case. The plaintiff in the case is challenging the federal law that requires federally licensed gun dealers, or prohibits federally licensed gun dealers from selling handguns to 18, 19, and 20-year-olds. And I believe if you're selling guns in any state, you have to be licensed by the federal government to do that. So the plaintiff was saying that that's unconstitutional, violates her Second Amendment right. And the Fourth Circuit panel held that it did. It was a 2-1 decision. 3 judges on the panel held that it violated her Second Amendment right. Now, none of these rights are absolute. There are always limitations on the right, and there are certainly limitations on the Second Amendment right to bear arms. We don't know a lot about what those restrictions are because the Supreme Court hasn't taken many cases. But this case, the court held that this infringement of rights the government wasn't able to justify it well enough. So therefore, unconstitutional. So it's only binding, though, on gun dealers in the Fourth Circuit, which is Virginia, Maryland, North Carolina, South Carolina, and West Virginia. It is directly contradictory to a Fifth Circuit case, Texas, Mississippi, and Louisiana, that held the opposite, that this federal statute does not violate the Second Amendment. So the question that I got, well, where does it go from here? Well, the first thing, the government, since it lost, they can appeal. And they would appeal not to the Supreme Court, but to the full Fourth Circuit. They can petition for what's called an en banc hearing, which is a hearing before the full Fourth Circuit, all of the judges of the Fourth Circuit. Almost all federal Circuit of Appeals cases are heard before panels of 3 judges. And usually that's the end of the case. Whatever that panel decides, that's the end. And a lot of our Fourth Amendment law comes from Fourth Circuit or from Court of Appeals cases, as we've talked about. So the government can appeal to the whole panel. The panel can decide whether they want to rehear the case or not. If they decide not to hear it, then the government can appeal it to the U.S. Supreme Court. And the Supreme Court, I think, would be very likely to take this case for the mere fact that you have a federal statute where one circuit says the statute's unconstitutional, the other circuit, the Fifth Circuit, says it is constitutional. So they got to get a ruling on this, because we can't have federal law differing from state to state. Now, if the government wins, then meaning the Fourth Circuit full panel decides to hear the case and rules for the government, which would overturn the panel, probably not going to go to the Supreme Court. But there's a good chance that this thing could end up in the Supreme Court in the next year or so. Interesting case.
Do states have the ability to enforce new federalism when it comes to something like this, or do they have to now comply with their 4th district ruling? Like, who has to follow it now? Can the state say, well, look, we know what they said at the federal level, but still under the state of Virginia, you're not selling your handgun unless you're 21.
Yeah. If Virginia has a version of the Second Amendment in the Virginia Constitution. But gun dealers have to be licensed by the federal government, if I'm not mistaken. And if they are licensed by the federal government and they're regulated by the ATF and all these federal agencies, then a state, I don't think, could then effectively overrule what these federal courts are saying. This is because the federal government is so involved in the sale of handguns by law. I don't know that states there's much that a state could do to circumvent that. This certainly is not my area of expertise, but there are serious federal concerns here, federal government concerns. So probably not.
So right now, with that ruling coming out, how long before it takes effect? It's
immediate. So as of the issuance of that opinion, federal gun dealers in these 5 states can sell handguns. Licensed dealers can sell handguns to 18, 19, and 20-year-olds.
Okay. So in Virginia right now, if you're 18, you go buy a handgun.
Correct.
You walk into a store, you say, I'm 18, I'd like to buy that Glock 17 right there. They have to comply.
Yeah, because the case was the plaintiff was suing for what's called injunctive and declaratory relief. She wasn't trying to get damages. She was suing for the court to say, stop enforcing this law. That's injunctive relief, which is she was granted. And declaratory judgment means the court is also saying, we declare this statute unconstitutional, therefore it can no longer be enforced.
Do you think they got it right? Or you think they got it right?
I didn't read the opinion. It's a very long opinion. It's over 100 pages long between the dissent and the majority. I don't know. I haven't read it closely enough to think it's correctly decided. It is based on Heller, the Supreme Court's decision in DC versus Heller. That's where they draw the authority for the ruling. So I'm not prepared to speak on whether I think the court got it right here.
Gotcha. Cool. Fair enough answer. All right, let's move on to your Miranda issue.
All right. So the last couple weeks on the Facebook group, I've been posting some scenarios that deal with Miranda issues.
By the way, people have really been giving you dabs and a lot of accolades. People have been writing me like they're really fucking good.
Yeah, and I appreciate that. And those, anybody that's been to my classes, that's how my classes are. I mean, those scenarios they're not taken directly from my classes. They're kind of simplified versions of, but that's how I teach constitutional law to in-service officers, is through the use of those kinds of scenarios where it involves discussion. So I came up with some Miranda scenarios, try to keep it simple so that only 1 or 2 issues per scenario come up into play. A little bit about, well, obviously you can tell by the results, because you can see how people vote for what they think the answer is, that we're all over the place. I think the last one I did, less than 10% of the people got the correct answer. Now it was a 2-part answer. Some people got half the answer right, but less than 10% of the people got both questions correct. There's a lot of misunderstanding about Miranda, and it's understandable why, because it can be confusing. Just a little bit of background. Miranda obviously comes from the 1966 case, Miranda versus Arizona. And what that case, the significance of that case is it's the first time Supreme Court said explicitly that the Fifth Amendment protection against self-incrimination applies not only in court, where a defendant doesn't have to take the stand in a criminal trial. It also applies to police custodial interrogations based on the Fifth Amendment. And then the other significant part of the Miranda case was that what we now know as the Miranda warning has to be given prior to any custodial interrogation. When
we say custodial, let's start there. Just real quick, maybe 15 to 30 seconds.
Okay.
And just explain what's considered custodial.
We could do, I plan to, we could do at least half a podcast on this. And none of my scenarios have really dealt with this question, because it is in depth, but very briefly. When we're talking about custody, and I refer to it as Miranda custody to distinguish it between Fourth Amendment custody, because they are different. We're talking about arrest or arrest-like circumstances. That's what we mean by Miranda custody. Clearly, if
Not like an investigative detention or a traffic stop.
an investigative detention, some investigative detentions, a minority of them could rise to the level of Miranda arrest-like custody, meaning it looks more and it feels more like an arrest, although it's legally it's not.
Like a de facto?
It's a de facto. Well, de facto arrest is slightly different, but it's not the majority of our investigative stops. Clearly not traffic stops. Your routine everyday traffic stop is in no sense of the word custodial in the Miranda sense.
Berkman v. McCarty.
Yes, exactly. That's the case.
That's 68. Was it 68? 78?
I think that was in the 80s, if I'm not mistaken.
I think it maybe started in 78, made its way to the Supreme Court by the 80s.
Yeah, I'm not sure exactly, but it's clear. Yeah,
Okay.
Traffic stop is not arrest-like. It is much more akin to a typical Terry stop, brief encounter, and Miranda is not required. Until you get into those arrest-like situations, some of those things can be, and there is no one single test. I mean, but the use of handcuffs certainly is an arrest-like factor. Locking people in the back of a police car, being surrounded by a whole bunch of police officers, being accusatory in your questioning. All of these things are factors that would go into determining if somebody is in an arrest-like custody. Obviously, if you tell them they're under arrest, then we're done. We must read Miranda before interrogation. So custodial interrogation is the key. Custody plus interrogation.
And when we talk about interrogation, we're talking about questions designed to elicit a confession or an incriminating response,
Exactly.
not booking procedures, not typical stuff, right?
Yeah, and that's a good point. A lot of officers think that you can only interrogate someone if they're in custody. They're two completely separate things. I can interrogate a suspect in a non-custodial environment. We do that all the time on a traffic stop, or a pedestrian stop based on reasonable suspicion. Whenever you ask questions that a reasonable officer would know are designed to induce incriminating responses, then that's an interrogation. Are these your drugs, for example? That's an interrogative type of a question.
How about this? Are these your drugs? Yes, they are. Does that trigger Miranda at that point?
It depends. It depends on, are they in handcuffs? Are they surrounded by a bunch of police officers? What have you done before that?
What is this? How about this? What does your state's case law say? I mean, you've read case law from state to state. I recall a case just off the top of my head out of Texas where there's a pursuit and the motorcycle crashes. They handcuff them, stick them in the back of the car, and start asking them questions about the pursuit and getting incriminating responses. And the court said, nope, you still aren't under arrest at that point. That's Texas. You pull that shit in Jersey, whole different story. Does that make sense?
Yeah, I mean, asking someone a question and their response is essentially a confession. Yes, these are my drugs. Would a reasonable person think that they're about to be arrested? That's the question that we're asking there.
But it could vary on state by state.
Yeah, it's going to vary state by state and circumstance to circumstance.
Yeah, so it's important for everybody to know that if you're going to be researching Miranda, essentially starting at the Fourth Amendment is great with the Supreme Court of the United States, but certainly reading your state's case law regarding some Miranda issues is going to be paramount. And the reason I say to start with Fourth Amendment first or the SCOTUS opinions is because maybe your state hasn't explored them, and at least you know what the foundation is, and to see if they depart from it or make it any more strict for police officers in your state. Or sometimes, I don't know if you feel the same way, it feels a little looser. Does that ever feel, you ever see that stuff? Feels a little more loose?
As far as Miranda custody versus the Fourth Amendment?
I'm talking even some circumstances. Let's take, for example, let's go over to Minnesota v. Dickerson. Some states have interpreted Dickerson a little differently than the federal government has. For example, I know for a fact in states that I just taught, and maybe Michigan, or I'm pretty sure in Wisconsin, the feeling of a pill bottle they considered to be, and they talk about, we're not requiring officers to have an immediate conviction. Probable cause. You're feeling a pill bottle in somebody in these circumstances, even though it's not a per se illegal item. Pill bottles are commonly used to store narcotics. We can prove that, and that would be okay as an exploratory search under the rule or the thin line. I don't know what you can call it, like the small margin you have for a Terry frisk. You've seen things like that?
Yeah, I mean, if you're doing a pat down, a frisk for weapons, and you feel what's clearly not a weapon, but you have a reason to believe it's contraband, if you have, or a container that houses contraband, or commonly houses contraband, the question then becomes, do I have probable cause to believe that? And if I do, then yeah, I could reach in and do a further exploration. And if it doesn't, my PC doesn't have to come just from the touching of the item.
And in some states, they say, no, you better make sure it's something that's inherently illegal. So some states say, no, look, you felt that, we're good with that. And some states say, not here.
Yeah, I know New York, for example, I believe New York is the only state that doesn't subscribe to the quote plain field doctrine.
Yeah, I think that I could be out of my mind. I could be misquoting it, but I think there's another state too that I don't want to say this, but I thought I read something else that they were saying, not here either. We're not even playing. We got to look at that in Massachusetts.
It could be under the state.
I could be wrong on this.
Yeah. New York interpreted under the Fourth Amendment that there's no plain field doctrine. But they're the only state that's done that. But there could be states that have done it under their state constitutions. Yes.
That's correct. Yeah. Okay, good. Gotcha. Okay. So listen, I try to not interrupt too much, but give clarity as we go along, because I know where my mind's going to try to get to that holy grail of what we're trying to get to. We've got to probably answer a few of these smaller questions to have clarity to get, okay. So we've covered some ground. I don't mean to interrupt you, but I just want to make sure we're being clear with everybody. Carry on, sir.
Yeah, there is a lot to understand with Miranda, and one of them is knowing what triggers the Miranda warning, the custody and the interrogation.
So when somebody believes that they're going to be placed in formal custody, is a good place to be.
First of all, it's an objective test. It's not whether the person it's not whether the suspect that we're talking about, whether he feels like he's under arrest or restrained at the degree normally associated with arrest. It's whether a reasonable person in his position. And that goes to one of the scenarios that I talked about. The first one I did, I believe, it was a kind of a hybrid. It was a Fourth Amendment / Miranda question. This was the one where the officer has the arrest warrant in his hand for a suspect. He sees the suspect walking down the street. He approaches the suspect and engages in an otherwise voluntary encounter or voluntary contact and asks incriminating questions. He has the warrant, but the officer never says anything about the existence of the warrant. The officer knows at the end of this conversation, this guy's getting arrested. Doesn't matter what he says, I'm going to arrest him, but the officer doesn't communicate that fact. And my question was, is Miranda required because he's not in fact free to leave? He's going to be arrested. And the answer is no, Miranda's not required because the main reason is the fact wasn't communicated to the suspect. So no reasonable person, based on the circumstances of the scenario that I gave, would feel as though they were under arrest or otherwise not free to leave. It doesn't matter what the officer thinks because that would be a subjective test. It matters what a reasonable person would feel in that situation. So until the officer says, hey, I got this warrant, the existence of the warrant didn't matter. So Miranda wasn't required.
We have a case in New Jersey that came out recently, and I'm not super familiar with it, and I don't want to quote it, but it had something to do with failing to inform somebody during an investigation that they had charges for the crime that they were being investigated for. So essentially what occurred here in New Jersey, if I can recall correctly, and don't quote me on this, is they had probable cause to arrest the gentleman. They had on the charges they were going to interrogate him on. Mm-hmm. They brought him in to the police. I don't know a lot of the factors, but the fact that they didn't tell him that they already had enough to arrest him was an issue in New Jersey, where they said you needed to have read Miranda to them, being that you already had enough probable cause to arrest him on that.
And I think I don't know the particular case, but the fact that they probably communicated some of that to him during their interrogation, that, hey, it's looking more and more like you're the guy. And we're talking about an interrogation at a police station too, apparently.
Yeah, that's the other factor. Right.
But it all hinges on what are we communicating to our suspect, and how would a reasonable person interpret what is being communicated to him or her.
Okay. Yeah. And again, I wish I would have done my homework on that one before I got here, because we dig deep into those and we start using our fine tooth comb to go through it. Go, there was the issue, right? Sometimes I read people's cases. They'll send over incident reports, and please, this is not an invitation to send your incident reports to me. I do not have the time to read people's friggin' incident reports. There's just no way even for a lot of the legal questions that come my way, I have to defer to Zach and Mike Brazil at the moment because I don't have the time to sit and do the research, and these guys are in it nonstop all day. I am transitioning a little bit from being somebody who's reading case law all day to building this company and providing everybody with enough instructors to have more practical classes to apply into the field. So my dynamic shifting a little bit. I'm still very knowledgeable, but I don't have the time to sit and do the research for 18 minutes to answer one question, where Zach and Mike might have right at the tip of their tongue and be able to help you more appropriately. I hope you don't feel like I'm bombarding you with that stuff either, Zach.
No, I get a fair amount of them, and I try to answer all of them. I might miss a few.
And you do a great job. Yeah. Okay, so back to this. We are now. Where do we leave off?
So we were talking about what is the definition of custody, what is interrogation, so that was the first scenario that I dealt with the arrest warrant. The other two deal with, well, once someone has invoked a right and they focused on the right to counsel, what do we do? So I want to talk about that. There's lots of things that we can talk about, but I want to talk about the right to counsel. So we had one of the second scenario that I had, we had a guy was under arrest for a particular crime. We'll call it crime A. There was a warrant issued. He's under arrest. The officer reads Miranda and he says, I don't want to talk to you about that, inferring that it's the crime that you've arrested me for. I don't want to talk to you about it. I want a lawyer. So he's clearly invoked his right to counsel. He's in custody. So I think every officer is good with interrogation ceases immediately. So in this scenario, he is then held in jail without bond. So our suspect has been arrested. He invoked his right to counsel. He gets no bond, so he stays in jail. We just had an arrest warrant issued. He hasn't been arraigned yet, so he hasn't gone before a judge.
Big factor, right? Big factor. Yeah.
Because arraignment is where the Sixth Amendment right to counsel is triggered in most states. I found out from Ken Rice that in New York, the issuance of an arrest warrant is the triggering event. So that the answer to my scenario would have been different under New York law, but the majority of the states say that the issuance of an arrest warrant is not what's called a critical stage of the prosecution, doesn't trigger the Sixth Amendment right to counsel. So we're still dealing with the Fifth Amendment Miranda-based right to counsel. He says, I don't want to talk about this crime. I'm under arrest. He's being held without bond. So the next day, an officer from the neighboring jurisdiction hears that our guy's in jail. He's also a suspect in crime B in neighboring jurisdiction. So the officer takes the opportunity to go down to the jail and try and interview him about crime B. Has nothing to do with crime A. So the officer correctly reads Miranda because he's still in custody. And this time he waives his right, the suspect, and answers questions about crime B, and they're incriminating. So in his trial for crime B, he is arguing that interrogation, he's now had second thoughts. He's talked to his lawyer, and the lawyer's like, yeah, you probably shouldn't have said anything to that officer. So we're going to try and get that suppressed. So he says that second interrogation violated my Fifth Amendment right to counsel. And the answer is that it did. It did violate his right to counsel. So a couple points, real quick points. Miranda is not charge specific. So if someone invokes their right to silence or right to counsel, all interrogation on all matters has to stop. You can't just change the subject and we'll say, well, let's talk about this crime. Once invoked, that is the end of the questioning, at least for right now, unlike the Sixth Amendment right to counsel, which is charge specific. So what we're not talking about Sixth Amendment. So it's not charge specific. And under the Edwards rule, Arizona versus Edwards, the Supreme Court said that once an in custody suspect invokes his right to counsel, Fifth Amendment right to counsel, all interrogation must cease and no further police initiated interrogation may occur while he remains in custody. Couple points. The suspect at any point can initiate interrogation. That's fine.
So let's stop there for a second. That's my next question for you. So let's say the suspect has a change of heart 30 minutes later and goes, all right, I'm ready to talk to you guys. I waive my rights.
Well, we want to do a fresh Miranda warning.
Okay.
So this is a suspect initiated interrogation. So we're good on, doesn't matter. Edwards doesn't come into play. We're going to if he's still in custody, We're going to read a fresh Miranda warning, and we're going to get that explicit waiver. I want that. Do you understand your rights, and are you willing to talk to me? Yes or no. We want to get that explicit waiver this time as opposed to the implied waiver. And then he says, yep, I'm willing to talk to you. Then we begin our questioning. So that's outside the scope of the Miranda rule, of the Edwards rule. He initiated, not the officer. So in our scenario, we have a different officer and a different crime on a different day. How is the officer supposed to know that he invoked his right to counsel the day before? Well, Arizona versus Roberson tells us that it's the officer's duty to find out. Okay, if he's in custody, he cannot be subjected to any more interrogation while he remains in custody unless he initiates or counsel has been provided and is present. And in this case, the officer did not do that. So it's inadmissible.
Let me ask you this. How about, I'm probably getting ahead of you here, so I got this one. Let's say the guy bails out. He's released. Yep. Is there a time period that we have to have before we can reinitiate or reengage with him?
Beautiful segue into the last scenario, the most recent one that I did, which is very, very similar. So he gets, let's just continue with our guy who we have in custody right now. He now bonds out on, remember, he's in jail on crime A. He now gets a bond and he's released from jail, still has not been arraigned. Okay, but so he's still out and about in the free world, hasn't gone to the judge yet. So let's do crime A. So now he's at home the next day. That same officer that arrested him the other night says, well, let me give it another shot. Maybe since he's at home now, he'll be willing to talk to me about crime A. So I go and knock on the door. The suspect answers the door. The officer says, hey, remember me? Sure. I'd like to ask you some questions about this crime that I arrested you for the other night. Would you be willing to answer my questions? He says, sure, ask your questions. And he makes incriminating responses. Is this interrogation, which this is an interrogation, right? We're asking incriminating questions. Is it a lawful interrogation? The answer is yes. He's no longer in custody. So that Edwards rule doesn't apply because he's not in custody.
It's been satisfied. That custody's been satisfied. He's released and a free man again.
Right. It's ended. The Supreme Court has never required a Miranda warning, a Fifth Amendment Miranda warning, for someone who's not in custody, regardless of what happened earlier. So under the Fifth Amendment, because he hasn't been arraigned. Now, if he'd been arraigned, this would be a Sixth Amendment right to counsel issue where we would have to address that, but that's for another day. Now,
I have a quick side question for you.
All right.
Am I interrupting you? You're going to lose your train of thought here?
I want to get to the 14-day rule, but go ahead with your question.
Often, people, this is an interesting one, and it's kind of comical. I'll get a call like this. Hey, we're working a case, and we develop probable cause to believe that this person committed a crime, not a misdemeanor offense, an actual felony. And maybe there's a difference between felony and misdemeanor. And then we see him 2 days later, but nobody's typed a warrant up yet. Can we arrest that guy, or do we still have to run and get a warrant to arrest him even 2 days later? Statute of limitations is 5 years.
Yeah, under the Fourth Amendment, the only thing required to make arrest lawful is probable cause. Doesn't matter if it's a misdemeanor or a felony. Doesn't matter if occurring presence or not, as long as you have PC. Now, a lot of states have state law rules that say if it didn't occur in your presence, you got to get a warrant.
For a misdemeanor.
For misdemeanors, yeah. Felonies, you never need a warrant for a felony.
So people will ask this question a lot. We'll have guys who are. We had a guy from, and this is a funny agency. These are these crazy agencies. They have a pursuit. Pursuits. I always find this comical. In New Jersey, a pursuit is a second-degree offense. It's graded the same as a attempted murder. What I find comical is that you'll have an agency that will investigate an attempted murder, but won't investigate an eluding, which is crazy. So it's really nuts. So like they just don't consider. Like if you commit a second-degree crime and you get away, most agencies here say, congrats, you won. They don't even look further into it.
End of the day, right? It's
yeah,
like
that's it.
Crime. Why wouldn't you investigate it?
Because people don't see it that way. Maybe other states don't grade them in the same account. So I'll have this one, like, we had a guy call me, goes, we had a pursuit. We actually matched the guy up. He had probable cause to arrest him. Our captain said, you can't arrest him. Come back and get a warrant, and then you can go back and arrest him. And I said, that's the most ridiculous thing. I mean, can you imagine if it was for a homicide? What's the difference? Mm-hmm. Are you going to let a homicide suspect leave because you didn't type a warrant up yet? back down to domestic violence. We have guys who have probable cause that a domestic violence incident occurred. And I'm like, yeah, then, and if this is the suspect and you guys have probable cause, you can certainly arrest. You don't have to wait and go find a judge to make the arrest on those if you have the probable cause. Is that correct in saying that?
Every state's different. I can speak to Virginia, misdemeanor. The general rule is in most states, misdemeanors that don't occur in your presence, you got to get a warrant first before you.
Unless it's one of the enumerated offenses, right?
It's an exception. And then there's always exceptions. And I've never seen a state where domestic violence is not an exception.
Yeah, that's going to be a big one. Shoplifting, generally the same ones.
Yeah.
Shoplifting, theft of library materials.
A lot. Brandishing a firearm tends to come up a lot.
That's not a misdemeanor. That would be so in our state, because firearms are so taboo here. Right. Everything firearms a felony here.
Yeah, Virginia, it's a misdemeanor. You can get a ticket for brandishing a firearm in Virginia. You can get arrested too, but it's a misdemeanor.
Okay, gotcha. Okay, I wanted to go over that because I think it's important for people to know that. That's a question I get frequently, and then we give the answer back to these folks, and I'm like, well, show me where it says that you can't do this, and they're like, well, we just wouldn't do it that way. It's literally, I often wonder where common sense has departed this profession. I'm sitting here constantly racking my brain on what the fuck has happened to this profession, and I think there's a lot of answers to it. I don't think there's just one blanket answer, and I think a lot of it has to do with sometimes it's the salaries, right? Like, I had this conversation with somebody yesterday. I said, when you have an agency that's paying $38,000 a year as top pay, you're getting two kinds of cops. You're getting the ones who don't care about what it is, how much they're getting paid. They're so committed to doing the job that they're going to show up and do it for peanuts. And you got the other ones who are taking a job that's available for 38 grand a year. I don't care what part of the country you're in. 38 grand a year is a fucking tough place to try to make a living on.
A lot of southeastern states, the salaries are very low. Like
Chattanooga, Tennessee.
Yeah,
dude, Chattanooga, Tennessee, $38,000 top pay patrolman. Mm-hmm. This company, we don't even start at $38,000. There's not a soul in this company makes $38,000 in my company. And I got 18-year-old. We have an 18-year-old, we have some 21, 22-year-olds. It doesn't start at $38,000. That's their top pay.
Wow.
It's nuts. Yeah, it's I tell these guys, this is the excuse you get. I'm going to use a Southern accent. Well, it don't cost much to live down here. My taxes ain't but $300 a year. What do you do for the rest of your life? You're stuck. I mean, you're not going anywhere. You're stuck in your friggin' town forever. Where are you going to
go? You're not going to live in the Northeast on a pension from your Southern.
You're not going to live anywhere. I mean, you're talking about these places are really particular. I mean, Nashville's through the roof expensive. So you're going to be stuck in fucking Chattanooga. Right, you're not going over to Virginia, where you live. It can't be that inexpensive anymore.
It's pretty expensive where
you know what I'm saying? Like
Virginia,
North Carolina said these places are going up. Florida has exploded. So where are you going? You're going nowhere. You're going to sit in your one horse town forever. Now, on a quick side note, practical, like you can do a lot to make up that deficit of money. If money's not your motivation for going to law enforcement, but you got to make a better living, like we have the internet. There's so many goddamn things you can do to make a ton of money. In the interim. But anyway, let's go back to the 14-day rule. It's one of my favorites.
All right, good. Yeah, so this will be my last point. Widely misunderstood. So in Maryland versus Schatzer, I believe it was in 2012, the Supreme Court put a limitation on the Edwards rule. Schatzer was a prison inmate, and he had invoked his right to counsel. He was being interrogated about a crime that occurred outside of prison. And he said, I want a lawyer after being read Miranda. So he was released back to the prison population, no further interrogation. They come back 2 years later to investigate the same crime. New evidence had come to light. He's still in prison. They read him the Miranda warning again, and this time he decided to answer questions, and he was eventually charged for this other crime. And he argued that the Edwards rule said that if I invoke my right to counsel, I stay in custody, which he did, and I can't be subjected to any further custodial interrogation. So even 2 years later. And the Supreme Court took the case to address this very issue. There has to be some point where the Edwards rule takes effect. Because what if he was serving a life sentence? He could potentially never be interrogated after invoking his right to counsel one time. And so they came up with an arbitrary number. They said, 14 days sounds good enough. If there's a 14-day break in custody, and for Schatzer, his break in custody was being sent back to the prison housing area. That's his normal life.
Yeah, and they said that those were some of the factors. He was never told he couldn't leave. I think they told him, if you want to go back to your cell, you can, and he was able to do so. Right, that was a big factor.
He was what a break in custody for you and I would be released back to our outside life. His outside life was living in a prison. So 14-day break in custody, regardless of where that break occurs, is enough to break the Edwards rule. So my scenario was, finishing up, we have somebody who's in custody. He invokes his right to counsel. He's released, and let's say he gets arrested 4 days later for another crime, or maybe it's something, maybe the same crime. He's arrested 4 days later, and then they try to interrogate him now. That interrogation is illegal because we haven't had a 14-day break between custody. Doesn't matter what we're asking him questions about, because remember, it's not charge specific. So the Edwards rule would bar this second interrogation because the custody was 4 days later. Now, if it was 15 days later, he was arrested 15 days later, then we can go ahead. The clock has been reset. There is some debate, and it's more academic than legal, like judicial debate, that this 14, and I saw a lot of the answers in the scenario on the website, on the Facebook page said this, that the 14-day rule applies just straight. Doesn't matter if he's in custody. So even if he's at his home, we can't go interrogate him because it hasn't been 14 days. And that's just not true. Once he's released from custody, that moment he can be reinterrogated in the jail parking lot. It doesn't matter how many days have passed because he's not in custody anymore. It's got to have a break in custody of 14 days before we can reinterrogate. But if there's no custody, we go back to Miranda versus Arizona. Custodial interrogation is what triggers the warning, and that's it.
Can I ask you a question? Do you let's go over some practical advice for people who want to effectually use a Miranda confession, maybe not know a lot about it, maybe some safeguards. And I know you and I have crossed paths on this in the past. The first thing I want to ask is this: would it ever hurt your case to prematurely read Miranda? So if you were at a point where you're like, do I need to read Miranda, and you read it, would it hurt I'm not talking about your ability to elicit a confession. I'm just talking about legally, would safeguarding it ever hurt your case? So if you were at a crossroad, you didn't have a lot of understanding of when it kicked in, you're saying stuff, man, maybe it kicks in now, and let me go for it anyway. Would it be smarter to read it prematurely or wait till later, till when you think you really, really needed it?
Well, it's not legally problematic to read it too early. It's clearly legally problematic to read it too late.
Yep.
Now, the only time I would say that it may create a legal issue is if we're dealing with a voluntary contact. And maybe I'm just so unversed in Miranda that I read a Miranda warning because this is a voluntary contact, but I know I'm getting ready to ask him whether he committed a particular crime. So I want to go ahead and do the Miranda warning. Does that create a legal problem? I would argue that what do people closely associate with? If anybody that watches movies,
an arrest.
Yeah, if somebody's giving me my rights, they would think they're under arrest. So
right.
I would defeat my argument that this is a voluntary contact. But I don't know that a court would say that by itself would trigger it. So to answer your question, no, it doesn't create a legal issue by reading Miranda too soon. It does perhaps inhibit effective investigation because someone may say, hey, that's a good idea. I don't want to talk to you then, or I want a lawyer. And if we
I agree.
Maybe he wouldn't have said that.
And when I ask this question, I'm really in my mind envisioning a portion of maybe a traffic stop or an investigative detention where we're starting to get into that arena of like, this is really feeling like it's arresting territory. If we don't have probable cause, we're close to it. Do I read it? Like we're so close, I can taste it. Mm-hmm. I don't know when it kicks in. Rather safe than sorry, maybe a little bit at that point. I'm not saying like as a bright line rule, every time you say hello to
I lost you.
The officer has to really know. Actually, all police officers throughout history, but now more than ever, they really be kicking in, right?
Yeah, I mean, you as a risk management tool, yeah, I would read it if I wasn't sure. Just like in this particular case, I'm not sure, then absolutely read it. But from a long-term perspective, I would invest a little time and energy in learning what the rule is. I'm not, and anybody's been to my classes and we talk about this issue, I'm not a proponent of premature Miranda warnings.
I agree. I agree. I know that there are people who are not going to take the time. 99.9% of cops are not going to take the time to understand what it is, when it is, and how you have to read it. And by the way, 97% of them don't even know that that's an issue. They're just going off what they see on TV or what's been told and passed along. Right. We had an agency that New Jersey Transit years ago. They would have an arrest. They would use our police stations. We had three train stations in our town, and they would come in. And I never forget, they would sit people down under arrest because they would use our area to process them. They would actually just use their own books to sign their complaints on. They'd use our system. Right? They just needed a place to process people. Take a picture, get them into the system, the whole nine. And it's Jersey. I mean, we couldn't do enough for each other. You know what I mean? I'm basically carrying the guy in by his shoulders. I mean, on my shoulders. That's how much we take care of each other here. And I never forget him taking out his Miranda card and reading Miranda right before booking procedures began. And I'm like, what are you doing? He's like, I have to read Miranda every single time. It's a carte blanche SOP here at New Jersey Transit Police. Every time somebody's in the arrest, we have to read it. Yeah, and again, just comes down to somebody trying to play this disaster control of, God, imagine if we get a confession and we didn't read Miranda. New Jersey State Police puts it in their, like, it's triggered so early. And some of that has to do with the psychological deterrent from our state police doing active, proactive criminal police work. They don't want it. They don't want guys doing interdiction work. The New Jersey State Police, it is a big no-no. It's no secret here. So they put these things in place, and what happens is they set them, they're trying to do like it's quality control or disaster control, but people are trying to figure out ways to circumvent this stuff to try to achieve their objective. And what they're doing is they're not maliciously, but trying to figure out ways. If you would just follow what we had, you would have competent state police, state troopers here being able to achieve law enforcement objectives without having to put additional, administrative or agency related hurdles in place. All they're doing is serving up a shitload of defense attorney strategies by when they take their SOPs and put them on the stand and say, you didn't follow this SOP. And you could say, well, I followed the law. It doesn't matter. We're going to cross-examine you on why you don't follow your agency's SOPs. And it's a strategy defense is going to play. Would you agree?
Yeah. And I would come back with an agency. If you have a policy like that says you have to read a Miranda warning every time you arrest someone, or you do it just as a matter of personal policy. What if you're reading Miranda and you have no intention to interrogate this person, but the detective is waiting for this guy to be brought in because he's got some questions that he wants to ask this guy. If I read Miranda as a patrol officer or deputy on the street, just because I just do, and then he says, I want a lawyer. We've already talked about what happens. Now my detective cannot come back and interrogate him while he's in custody. Because I think the
state police in New Jersey, they have a rule, like you can't talk to somebody on a traffic stop until you read the Miranda.
So what do you do when they say, we want a lawyer? You don't talk to them anymore. And plus, you don't even have a right. So that's another problem. When you read a Miranda warning, when someone's truly not in custody, half of it's not true. You don't have a right to counsel when you're not in custody.
Right.
That's my second argument about premature. It inhibits effective investigations, and half of it is a lie. If you're not in custody, you don't have a right to a lawyer. You have a right to remain silent, but you don't have a right to a lawyer.
And by the way, listen, somebody is going to get their feathers ruffled on this statement, but like, I don't have the top level command coming in and asking the questions like, is this correct? Is this not correct? What do you think? Can you ask that guy, Zach Miller, maybe to change things? I'm just calling, like, it's just the fucking truth. Like, this is what they do. And these guys ask me all the time, like, what are we supposed to do? I'm like, nothing. They don't want it. They've clearly, here's one. They've tried to defer them because they had a consent decree that comes out, I think in 96, racial profiling, bias thing, the whole nine. Yeah. What they do is they say to try to get these cops to stop doing police work, what they say is you got to write a police report every single time somebody steps out of a car. So now you got troopers in state New Jersey who won't never ask people to step out of cars. This not only creates a major issue. You know what? I'm saying this at the detriment of me having some collateral damage from opening my mouth about this stuff because it's so hush hush. But it is what it is. You've got scenarios that from a strategic tactical point of view would be far more important to have somebody step out of a car on a traffic stop, may cost you your life, but these guys and girls are now apprehensive to do that because they have to write literally a full page report on why they did that. So
Legally, you
what
don't
you would
have to
see,
have a reason.
what you would see these guys and girls doing is taking their pens. You'd see them on the side of the road, giving SFSTs with people sitting inside their cars.
Mhm.
So the state police got hip to that because they like DWIs and got, listen, they're allowed to do whatever they want. It doesn't matter to me. I'm just making a point here. So they said, okay, you have to write a report on a traffic stop when somebody gets in a car for everything except the DWI investigation. So now what do you think half the troopers are doing? It's a DWI investigation, right? Yeah, get the car. Oh, you didn't. I don't know. I think you're, like, right. And it's them trying to do the work that they were hired to do and trying to fight crime within these parameters that are constantly being skewed from what everybody else has to do. And I'm sure they're not the only agency that has to deal with these things. And I say this where it might ruffle feathers from an administrative level, but it speaks on behalf of the guys and girls that are on the road. And I'm talking about everybody across the board who's frustrated with the rules that have been set forth. They're trying to do a job that's already difficult enough. And now they're adding on 20 different extra steps on everything that they do. I certainly have no issues with that agency. I think that they have some of the best, most talented people in the state. I know a lot of them. I'm friends with a ton of them. I think they're wonderful people. They have phenomenal professional courtesy. They are a cut above the rest when it comes to the standards. They wash out 45% of the bums that in their academy. They really are tough. It's a really, really great agency. But when we start talking about the legalities behind it, we've got to free these people up and let them get back to the work. You know what I mean? Without trying. And they're just like, they're like, I don't understand. You guys say that that's not true. And I'm like, it's true for everybody else. It's just not true for you guys. Have you ever seen other agencies trying to curtail or do stuff like that to?
Well, a lot of policy is, and it doesn't matter where you go. It's a lot of policy is developed because one guy did one thing. Whether it was some evidence that got suppressed or he didn't wear the right color socks to work or something. Ugh. And then now we have a policy that covers it in detail and sometimes is overbroad. And yeah, that's no matter where you go.
Yeah, isn't it insane? Yeah. Knee-jerk reactions are probably the worst thing you could ever do. You got to remove and let emotions settle. There's a great saying, and it says, just stand there, don't do something. Right? So everybody talks about, don't just stand there, do something. It's just the opposite. Just stand there, don't do something. Not yet. Yeah. Give yourself some time to think.
Percolate and think about this thing critically and objectively. Yeah.
I mean, no, I know. And it comes down to the fact that people who are making policies and SOPs are just and especially now, trying to appease the public. Don't worry. We took care of that. That guy said shit on that video. We put an order out that says you could never say shit. So they got a guy in a deadly force situation yelling, get on the fucking ground, which is 100% justified. If you're in a deadly force situation and you've got to use foul language to control the scene, I'm not saying you need it professionally. I'm saying in a hot situation, yelling, get on the ground, motherfucker, is a great way. I would certainly argue that it's much more professional than putting a bullet in somebody's head if you can get them to listen to you on constructive authority. You know what I mean?
One of my favorite policies or rules, I call it I can't take credit for it myself, but I use it as a rule on deviating from the rules. So having a policy that allows deviation from every other policy that we're getting ready to put out for you under certain circumstances. And this would be one here. We have a no profanity policy, but we also have a policy on deviating from policy, which puts the burden on the officer who uses profanity to justify in writing why he felt it was necessary to use profanity. And if we think it's reasonable, then we don't charge him with a policy violation. So if you have a rule on deviating from the rules in your policy manual, I like that as a kind of a catch-all, because you can't craft a policy on most field procedures that we do. They're not
meant to be followed.
Single circumstance,
If you go to the military guidelines, they create SOPs as a guide, but you're not even supposed to follow them all.
Well, then I would argue, then why do we have them? I mean, I'm also not a fan of fake rules. We have a rule that says you can't wear white socks with a uniform, but half the guys are running around wearing white socks and nothing happens to them. Then that's not a real rule. Let's get rid of the rule.
Yeah, well, I'm talking about like, when I guess there's some recognition to that, some real malleability and some change, and not everything's going to, especially in situations that we're in, is going to fit into A, B, and C categories. So, hey, Like we need you to call this, this, and this in this order, but if it was a life and death situation, you can deviate from rule number fucking 4 to get to rule number 2 faster because, and like, we're not going to ding you on that. That's what, if you actually begin to look at military procedure, SOPs are meant to guide, but should not be black and white. So as long as you're following the basic principles of the SOP, where to go with it. When you're talking about things like that, I'm talking about more in the field practical stuff and an understanding that you can't follow the exact SOP. I'm saying you got to follow the legalities, how the law is written, but sometimes the SOPs are not written wisely, and you got to give people that ability to come off the leash and deviate from that a little bit with good intention, not with malfeasance of, I know my socks have to be black, I don't give a fuck. That's different. I'm talking about the necessity to have to maneuver through some SOPs. The problem with SOPs is they were designed to do essentially one thing, and that's getting people in trouble. Yeah.
I think a well-functioning agency has a well-written directive system, with written directive number 1 being, again, your rule on deviating from the rules.
You ever see in your career when somebody is being targeted by the administration and they take that fucking book out and they grease it up and get ready to put over somebody's body? I mean, I've seen internal affairs. I've even had them come towards me, and now they're hitting me on 11 different SOP violations that I didn't even know existed. You signed off on them 11 years ago. Right. You knew it existed. Whoa. What do you? Yeah, no, we looked under your pin is not where it's supposed to be on your uniform. That's a violation. Where was your tie? That's a violation. Just load it on. Like, what the fuck is going on here? So that's why I say, like, it's good as a guide, but when you start using them improperly, administrations and even people in the field, you have. They're not being used for what they're designed to be used for. If they were good intentions and supposed to be used as a guide to help understand and promote conformity and process, I'm with it. But don't take it and use it. We had the guy that I used to work for used to leave the 2 fucking books on his desk. When you come and talk to him, he wanted you to know that he had it on his desk, and if you fucked with him, and he wasn't a nice guy, he's a real piece of shit. That's just it. He's the most hated person. I don't give a fuck. I don't work there anymore, and that's what he's known for. He still does it to this day. Guys tell me, yep, got it on his desk. He wants you to know that it's there, and he'll use it if he has to. That's his game. Which
is not what they're there for.
Yeah. I know, but there's no accountability at the upper level command. Nobody's holding accountable. Got enough political connections to keep himself with good air cover. They don't give a fuck. I don't care. And hence, that's why we have issues. And I'm making Zach uncomfortable because we go off on tangents.
Not comfortable at all. These are issues that I know very well.
Mm-hmm. Anyway, I think this is good for. I get on these dentist rants, and I have to call these things out to promote progression. I don't know how else to do it. If we can't talk about what the problems are and knowing what they are, exposing what they are, how can we progress as a profession? I just don't know. And we're calling on every level. And I'm not perfect. I'm just trying to do the best that I can to try to get this thing fucking resolved a little bit, because we need help. And we can't continue to be okay with the way things were done and one of my favorite things ever, I'll finish with this. And if you have anything else you want to contribute, that's fine. We had a class heavy level supervisor. The guy raised his hand and goes to me, "How do I talk to these millennials?" I said, "Start off by not talking to them like they're a fucking asshole." That's a great place to begin, because I see a lot of commanders in here who came in here with some tough attitudes today. And I know how you guys act. It ain't 1978 where they're going to stand at attention in your office and carte blanche take orders and commands to go out when I'm telling them that the things you're telling them are incorrect or inept with how the law conforms that you behave. So when they're asking, well, you can't do that, or why? You can't take it as a shot back at you. You got to say, hold on, maybe I'm wrong. I don't know what else to say. Stop being an asshole. We'll start getting some stuff resolved. Open your mind, deploy some humility. I'd love to listen to it, right? Like, change your personality a little bit. You don't got to be romantic with the way things were in the past. And it's a sad state of affairs. You would not believe some of you would. You've been around long. 17 and a half years in now?
Almost 17.
Yeah. I can't wait to get you over here. We should get desks that adjoin each other face to face. And at lunch, we'll just close our laptops and look at each other and enjoy meatball
Stare
subs.
into each other's eyes.
Well, I think just have a nice general, 2 old timers sitting on a porch sharing some pie.
Yeah.
So anyway, everything else to contribute?
That was it.
All right, we'll cycle back around to something else. Are you going to be available next week?
Yes, I will be here most of the week. Yes.
The world needs you, Zach Miller. Make sure you take care of yourself because we can't have everything happen to our Savior, the Lord Zach Miller. Case law, trying to help. StreetCop.com. The conference is coming up October 4th through the 8th, 2021. Check us out on all platforms. If you like this podcast, tell your friends about it. Give us a rating, download us, do all that stuff that's important to us. We're asking for that. We don't charge things, but that's what we're asking in return as a favor. That's your fee for listening. Turn us on to other people, mention it to us. And we have a lot of cool stuff coming out. Check out StreetCop.com. Again, without further ado, Zach, it was wonderful seeing you. I will see you later, my friend.
Thanks. See you next time.
Hey, thanks for watching the video. If you liked what you saw, subscribe to our channel or leave a comment below and also like us too. It means the world to us.